Ladies and gentlemen, students, faculty, alumni, and staff, welcome to the first American Constitution Society event for the 2002-2003 academic year. The American Constitution Society, created in 1999, is a national organization of law students, professors, judges, and politicians dedicated to countering the dominant vision of American law today, a narrow, conservative vision that lacks appropriate regard for the ways in which the law affects people's lives. We seek to restore the fundamental principles of respect for human dignity, protection for individual rights and liberties, genuine equality, and access to justice to their rightful and traditionally central place in the American law. The ACS has grown in just over one academic year to include more than 50 student chapters and 4 lawyers chapters nationwide. That this has happened so shortly speaks volumes to the need that existed for this organization and to the enthusiasm of its members and supporters. Indeed, the most common responses I receive when I explain what the ACS is are, "Thank God, and it's about time." As many of you may know, last year, our first year at Brooklyn Law School, we sponsored several events, presentations, and debates on issues such as gun control, school vouchers, the judicial appointment process, and lawyers' social responsibility. This afternoon's presentation not only marks the beginning of a second year of such activities at Brooklyn, it is also a testament to the dedication and determination of our group nationwide. This week and next, student chapters across the country, 4 in New York alone, host presentations by federal judges from their districts on the topic of sentencing and the federal judiciary. We are very fortunate to have with us today, as Brooklyn's contribution to this national event, no stranger to Brooklyn Law School, the Honorable John Gleeson of the Eastern District. I'll now turn things over to Professor Susan Herman, who will introduce, for those of you who need introducing, John Gleeson.
Thank you, John. It's a pleasure to be here, and I'm going to be here at your first event of the year. I think the topic that you've selected for today is really a wonderful topic to discuss, because talking about federal sentencing, this topic is going to engage the question of the dialogue between the Sentencing Commission and Congress in terms of who makes sentencing policy for the federal courts and the government generally. And there are also a lot of issues about law that appears to be neutral on its face, but when you scratch the surface, there are a whole lot of issues about how issues apply, sentencing law applies to people on the basis of what race they happen to be. And there's a lot involved. And I think you also have a wonderful speaker to talk about this topic. Judge Gleeson went to law school, not at Brooklyn, unfortunately. It took him a long time to get back to Brooklyn. He went to law school. He went to college at Georgetown University and to law school at the University of Virginia, and then traveled from there to the Sixth Circuit, where he served as a law clerk for Boyce Martin, a judge on the Sixth Circuit, and evidently discovered right there that he liked life on the bench. Came back to New York as a litigation associate at Cravat, Swain & Moore, then became an assistant United States attorney finally in Brooklyn in the Eastern District. Over the next 10 years, he served as chief of appeals, chief of special prosecutions, chief of organized crime, and chief of the criminal division, which was the position he occupied when he was appointed to the bench. During that time, he was also a frequent visitor to Brooklyn Law School, where he taught courses. He also continues to teach. Judge Gleeson has had considerable experience in the sentencing area, has written about sentencing, and is also on the Defenders Services Committee of the Judicial Conference of the United States. So that's kind of the formal bio on the website that I'm reading you all this information from. But at an informal level, I'm teaching a first-year criminal law class, and I was just commenting to Judge Gleeson that all of the first-year students are unable to be here because they're having an outlining workshop today. But when I was telling my students before I was aware of the conflict about today's event and how interesting I thought they would find it, my informal part is I said to them, well, hearing Judge Gleeson would really be a treat because he really is one of the smartest judges on the bench around these parts. So it is my pleasure to introduce you to John Gleeson.
Well, thank you, Susan. That's very nice. Thank you, John, for inviting me here to speak about the United States sentencing guidelines, which we in the federal judiciary and everybody involved in federal criminal justice talk about, seems like all the time. It's a fitting topic for today's talk because on November 1st of this year, the guidelines will be 15 years old. Second only to watching my own children grow up. Nothing reminds me more of how old I'm getting than watching the sentencing guidelines greet these landmarks along the way. It really seems to people of yesterday that we got them. And they were born into a storm of controversy. They were promptly, that is within a year or two, found unconstitutional by more than 200 federal judges. They were roundly denounced as unfair by the judges who didn't hold them unconstitutional. But now 15 years have gone by. It's an appropriate time for a retrospective. A lot of the controversy has subsided. The Supreme Court has found them to be constitutional. Many of the most popularly held beliefs about how they would change federal criminal practice turned out to be wrong. Even most of the most vocal critics of the guidelines now concede that they're here to stay. So when we talk about them now, 15 years later, the stakes are a little low. We're not talking about whether we'll have them for the foreseeable future. They're here to stay, but it doesn't mean they're not extremely important. In fact, they're plainly the most important, most controversial piece of the federal criminal justice landscape. Now, this title of this talk that we have, the separation of powers in federal sentencing, in truth, that title made me kind of nervous. People a lot smarter than me, and there are quite a few of them, notwithstanding that misleading suggestion that Professor Herman just made, spend their professional lives thinking about and writing about and speaking about the separation of powers among our coordinate branches of government. And the truth is, I'm just a trench dweller in the federal system. I'm a laborer in the vineyards of federal courts. I have been now for 18 years, 10 as a prosecutor, a trial lawyer, and 8 on the bench. And the fact of the matter is, the power gets separated among our branches of government way before it trickles down to the likes of me. Besides, as strictly speaking, on the issue of separation of powers and the federal sentencing guidelines, the issue's already been decided in the Estrada case, to which I invite your attention. If you're interested in the more lofty academic separation of powers issue as it relates to the guidelines. What I really want to talk to you about is what affects us day to day in the federal system. And that is not so much the separation of powers as manifested by the guidelines, but really the allocation of power, the allocation of sentencing power by the guidelines and what the guidelines have done to that. Further, by way of preface, and I'm going to speak about the historical backdrop of the guidelines in a moment, but further by way of preface, let me say this. There's so much to talk about in connection with the federal sentencing guidelines. A number of truly important issues as to which some controversy, as we speak, rages. The relative weight accorded to crack cocaine, for example, as opposed to powder cocaine in calculating sentences, a very important issue. There are a number of others as well. I don't mean by focusing my remarks so I can hopefully say something substantive to mislead you. We could be here really for weeks talking about the sentencing guidelines. But I want to talk about a couple of respects in which they significantly reallocate sentencing power. It's important, I think, to lay some backdrop. Before the Sentencing Reform Act of 1984, which gave us eventually the sentencing guidelines, federal sentences were indeterminate. A judge would impose sentence for a specific term of years, but the percentage of time that the defendant would actually spend in jail was determined not by that sentence, but by the United States Parole Commission, an agency in the executive branch that had discretionary power exercised pursuant to its own guidelines, which in a certain respect became a precursor for the federal sentencing guidelines. Discretionary power to set release dates for the defendants anywhere within very broad boundaries. The judge in those days had virtually unlimited, unreviewed, unreviewable discretion to sentence a defendant anywhere within the range created by the statutory maximum and, in rare instances, minimum penalties prescribed by the statute that the defendant was convicted of violating, as long as the judge kept within those boundaries, and they were very broad boundaries. There were no rules about he or she made the choice of a sentence, no limitation on either the quality or type of information a judge could consider. The judge could and did consider defendant's troubled childhood, defendant's arrest record, education, family circumstances. The judge could consider uncharged conduct of any sort, of any stripe, rumored conduct underlying charges of which the defendant had been acquitted. There was no requirement in the pre-guidelines era that a judge make any findings of fact at the sentencing stage. Indeed, as long as the sentence did not exceed the statutory maximum, okay, or more precisely, the aggregate of all the statutory maximum sentences prescribed by all the counts of conviction, the judge could impose sentence and the Court of Appeals could not review it. If you had to characterize the pre-guidelines era by reference to one of the traditional goals of sentencing, I think you'd have to say it was essentially rehabilitative. Judges would impose the indeterminate sentence. The parole commission, assisted by criminologists and other professionals, would monitor the inmate and make an appropriate decision about when to release the inmate back into society. Well, in the 70s and the 80s, the early 80s, this rehabilitative model fell into disrepute, to put it mildly. Crime was on the rise. It didn't seem to be, not that this evidence, the social scientists will tell you, is ever easy to collect, but there didn't seem to be much evidence that prisoners were in fact being rehabilitated. At the same time, there was a growing concern across the political spectrum about this unguided, loaded with discretion sentencing that I've just described. Specifically that it was producing what was considered to be unwarranted disparities in the sentences imposed on similarly situated defendants. There have been many controversies about the guidelines, their fairness, their rigidity, their redistribution of this enormous power to sentence that had been, until the guidelines came into play, vested solely in sentencing judges, federal judges. Many of those controversies, and others as well, exist today, but the essential reason for implementing the guidelines, specifically that similarly situated defendants in the federal system were being sentenced quite disparately, remains, to my mind, indisputable. Our district illustrated this graphically. One of the most depressing battles in our endless war on drugs is waged against drug couriers who were arrested on incoming international flights. It was going strong, this battle, long before I became a federal prosecutor in 1985, right up here, right up the street in the federal courthouse. It continues unabated today. On any given day at John F. Kennedy International Airport, the number of poor, uneducated aliens with no criminal histories that are arrested coming off the daily flights from Bogota or Lagos or any one of a handful of other source cities for importation of heroin or cocaine is limited only by the number of agents available to arrest them and to process them once they're arrested. Before the guidelines came into effect, these lowest level of the drug defendants, who in all respects were utterly indistinguishable when it came to factors relevant to sentencing, received significantly different sentences depending on which judge happened to come out of the wheel when the case was indicted. It was a category of cases that just placed into very clear relief what all the participants in the process already knew to be true, and that is, put bluntly, some judges are extremely harsh in sentencing, some aren't. And again, so long as those sentences were within the broad statutory ranges, there was nothing either the government or an unlucky defendant could do about it. Now, with the collapse of the rehabilitative model, a resurgence of retribution of just desserts as a preferred goal of sentencing, and with this universal frustration that flowed from these wildly disparate sentences, there came a palpable hostility to judicial discretion in the sentencing phase. It produced an uncommon political alignment. Strom Thurmond teamed up with Teddy Kennedy. And that eventually led to this 1984 Sentencing Reform Act. Now, this Reform Act did a number of things. One is it eliminated parole, which led to greater certainty in sentencing. Back-end discretion exercised by an agency in the executive branch long after a sentence was imposed and reported in the newspaper disappeared. The Sentencing Reform Act provided for appellate review of sentences. Most significantly, it created the United States Sentencing Commission, which by 1987 itself created the federal sentencing guidelines. The commission was denominated an independent entity placed in the judicial branch. The Sentencing Reform Act made clear that sentencing would remain primarily a judicial function, but the commission was instructed to restrict judicial discretion in sentencing. And in 1987, or effective November 1st, 1987, it produced an extensive set of guidelines built around the premise that judicial discretion needed to be cabined and built around a sentencing grid, using detailed guidelines which provided a base offense level for each offense of conviction and numerous adjustments based on offense characteristics and other characteristics related to the offense or essentially the defendant's role in it. Not offender characteristics such as employment or age or socioeconomic status. They were rendered out of bounds. But based on offense characteristics, a sentencing judge would compute a score of between 1 and 43 for the severity of the crime. That's one axis on the grid. The defendant's record of prior convictions produced a second score called the criminal history category of anywhere from 1 to 6. So with these two scores as the vertical and horizontal axes, respectively, on the grid, their intersection provided a range of punishment for the defendant at issue. Now, obviously, even I can do this arithmetic. That's 258 ranges in all, expressed in terms of months in prison, from which the judge could select the appropriate sentence. Now, the sentencing judge could depart from the range in either direction, but only in exceptional circumstances. I'd drop a footnote here if I were writing to make note of the fact that we could talk, if we stayed here for days on end to talk about the guidelines, and we'd spend a full day on departures for reasons other than cooperation with law enforcement, which I'll get to in a few minutes. For our purposes today, it's sufficient to point out that the departure power was intended to be, and has turned out to be, limited. Departure can only be invoked in exceptional circumstances. The ranges themselves were narrow. The maximum of any sentencing range couldn't exceed the minimum by more than 25% or 6 months, whichever was greater. The point being that the previously unlimited discretion, or rather limited only by, in virtually all cases, probation on the one end and the statutory maximum on the other end, now became discretion to impose sentence within a narrow range. And since the judge was required to stay within that range, absent a departure, federal sentences became more predictable. since the judge is required to make findings before any guideline adjustments can be made, and must explain her reasons for imposing a particular sentence, including any reasons for departure. The sun in the guidelines era shines in on the sentencing process and sentencing decisions in a way it never did before we had the guidelines. Now, it's certainly subject to debate, I suppose, but I'll suggest to you that the consistency and especially this transparency in sentencing that flowed from the sentencing guidelines is a monumental improvement in the federal sentencing regime. Less defensible, and again, perhaps a topic for another day, is the severity of the guidelines themselves. There are many who approve of the certainty and transparency in sentencing, who are upset, even outraged, in my view, with some justification, by the harshness of some of the authorized or really prescribed sentences. The length of federal sentences has more than doubled in the first 10 years of the federal guideline era. The federal prison population has exploded under the guidelines, although the Commission was instructed by Congress to take into account the nature and capacity of the penal, correctional, or other facilities and services available. That's a quote from the statute. The Commission was directed to take those capacities into account when it formulated the guidelines, yet the federal prison population has almost quadrupled since the day the guidelines became effective. But let me turn to the issues I want to focus on in my remaining time, and that is how the guidelines have redistributed sentencing authority. I'm going to focus on two ways. If I have time, I'll focus on a third, all of which relate to federal prosecutors or federal investigators. The sentencing guidelines empower federal prosecutors, purely and simply. That may only be the result of a relative diminution in the authority of sentencing judges as opposed to prosecutors, but the net effect is plainly an indisputable empowerment of federal prosecutors. They single-handedly and, in my opinion, inadvertently, created a new tool of federal investigations, and that is cooperation bargaining with participants in crime. Now, in this regard, I speak largely, not exclusively, but largely based on my experience as a prosecutor when we got these, because I was a prosecutor before the guidelines and for half a dozen years after the guidelines came into effect. It's impossible to overstate the impact of the guidelines in this respect, in how they created a tool of federal investigation. In fact, I believe that if Congress, instead of creating a sentencing commission, had simply just told the Department of Justice to go out and create a sentencing regime that will maximize your ability as prosecutors to enlist the cooperation of targets of federal investigations and defendants in federal criminal cases, I don't think the Department of Justice could have done any better than the Sentencing Commission did with the existing sentencing guidelines. The guidelines turn targets and defendants into accomplice witnesses. They have altered in a significant manner the way federal investigations are conducted. Let me explain how. Apart from the departure mechanism I alluded to earlier, available only in exceptional circumstances, and hardly ever to the people whom federal prosecutors want to turn and become their witnesses. The only readily available escape from the otherwise essentially mandatory sentences prescribed by the guidelines is to cooperate with the government. Section 5K 1.1 of the sentencing guidelines allows the court to depart from the applicable range if the defendant's cooperation resulted in substantial assistance to the government. And in stark contrast to how the applicable range is computed to begin with. That is by reference, by an almost mechanical, accountant-like finding of facts and attribution of levels of increase or decrease. There's no structure whatsoever to the downward departure based on cooperation. A defendant whose guideline range is 324 to 405 months can be sentenced to any lesser term or not incarcerated at all. Now, there's a catch. This type of downward departure requires, in the terms of the provision that authorizes it, a motion from the prosecutor. And the government has essentially, this has all been developed through case law since the guidelines came into force, has essentially unreviewable discretion, limited only by constraints, invidious, unconstitutional motives, race, ethnicity, and the like. Apart from those constraints, the government has unreviewable discretion in determining whether to enter into a cooperation agreement. If it does, it invariably reserves an enforceable right to determine for itself whether or not the defendant in fact rendered substantial assistance and thus becomes eligible for the motion, which then renders him eligible for the downward departure. This new regime gave an enormous boost to federal law enforcement. At the time, I was conducting organized crime investigations, something I did for quite a bit of time in the U.S. Attorney's Office. And the guidelines altered our strategy significantly. Before the guidelines, it was almost unheard of to flip, as we used to put it, targets of investigations in organized crime. It was especially true during the investigative stage, which is when you need it the most. And the reason for that was it identified, the investigators would identify someone whose cooperation they wanted, and they'd bring them in or take them to some secret location and make a pitch to try to enlist their cooperation. The problem in that pitch, and this problem would be identified during the colloquy with the prospective witness, and in that witness's discussions with counsel, who would invariably be present, defense counsel. The problem was there was no certainty back in the pre-guidelines era of what the benefit would be in cooperation or what the consequences would be if the person went to trial and was convicted. The reason for that was some judges were lenient no matter what, with or without cooperation. By the same token, some judges were harsh no matter what, even if the defendant cooperated. So in the investigative stage, when it wasn't clear which judge would get the case, it wasn't clear that the benefits of cooperation would outweigh the substantial costs of becoming a witness in an organized crime case. The availability of parole eligibility after 1/3 of any sentence that might be imposed further blunted the force of these arguments, these efforts to enlist witnesses. This new regime gave us a new pitch. The target would be walked through the guideline calculation that would apply, would be shown precisely where he fell on that sentencing grid. The bottom end of that range, the target/prospective witness would be told, would be the very best he could do, even before the most lenient judge. And the sentence would be without parole. That is, it would be a certain sentence in that amount. The witness would then hear from both the attorney, the defense attorney, the witness's attorney, and the prosecutor that the only certain way out of that box on that grid was to cooperate with the government. And especially in investigations involving murder or not even large quantities of narcotics. That has to do with the severity of the sentences prescribed by the guideline range. The inducement was enormously powerful. It produced far more cooperation and accomplice testimony in organized crime cases than occurred in the pre-guidelines era. The same effects were felt in white-collar investigations, and to this day, last week we tried a fraud case involving accomplice testimony, and I see the results as we speak, essentially, of this tool given to prosecutors. It's worth, I think, describing to you how prosecutors use this power at trial. Now, while the guidelines condition leniency for cooperation on the prosecutor's initiative, right, it requires that government motion, this so-called 5K 1.1 letter. And I tell you, it was remarkable how quickly all this caught on, and 5K 1.1 became part of the lexicon of gangsters in the street. We arrest people, and they get in the car. I would arrest them. The agents working with me would arrest them. They get in the car, and the first thing they'd say is, "I want a 5K1." They didn't even quite know exactly what it was, but they knew it was something really good. It was like RICO. Some people we arrested actually thought RICO was a person who was bringing down an organized crime thing. Here's the way it was used. Prosecutors are allowed to condition leniency, or rather the leniency is conditioned on the prosecutor's initiative. But then the prosecutor can step away and delegate to the court, the sentencing judge, the task of actually dispensing leniency. The distinction is critical to the credibility of accomplice witnesses on whom many federal prosecutions depend. And it's not as though prosecutors can't confer this leniency directly. They can, right? The prosecutor can agree not to charge a cooperating witness. He can grant immunity to a cooperating witness. A prosecutor can control a sentence through charge bargaining and allow a defendant to plead to a lesser charge, the statutory maximum of which will cap any sentence imposed by the judge. A prosecutor can also, under 11E1C of the Federal Rules of Criminal Procedure, agree to a specific sentence, subject, of course, to the approval of the court. But all of these options by which the prosecutor can confer leniency directly and control the degree of leniency to a cooperating witness raise a common problem. When the accomplice testifies, the jury learns that he or she will receive lenient treatment, and the terms of the leniency have been set by an interested party, by the government. That fact bolsters the standard defense argument that an accomplice's willingness to testify in exchange for the prosecutor's leniency makes him an unreliable witness. It feeds right into the standard defense argument. To minimize this problem, prosecutors have very effectively, from the time I was a prosecutor to today, done the following. They enter into a plea agreement that requires the witness to plead guilty to his or her most serious crime. In return, the accomplice witness gets only a substantial assistance motion, 5K 1.1 motion, and a report to the sentencing court of the nature and value of the cooperation rendered. This agreement allows the prosecutor to get up before the jury at the end of the trial and argue to the jury that any leniency the witness will get will come from the court, not the government. And of course, the court, the sentencing judge, has no stake in the outcome of the trial and will be lenient only if justice truly requires. When, as is almost always the case, the accomplice has pled guilty to the most serious crimes that he or she has committed, the prosecutor can say to the jury that if the witness spends 1 day less than the maximum authorized sentence in jail, it's because the court, the judge up there in the rows, and not the prosecutor, thought that is the right result. So why should the jury not listen to what the accomplice witness has to say if the testimony is given in those circumstances and under those terms? I assure you this, that argument works. The accomplice ordinarily would be sentenced by the judge before whom he testifies or she testifies, Judges are presumably, juries believe this, and I think it's true, concerned about the truthfulness of an accomplice's testimony, not its effectiveness. As a result, the prosecutor argues the agreement channels the accomplice's selfish motives into a desire to tell the truth. Now, obviously, the scheme collapses if judges don't reward cooperation and are perceived by prospective witnesses as rewarders of cooperation. But in fact, they do, sometimes very generously. The point is, by creating a system in which a prosecutor alone can make an accomplice witness eligible for leniency, but structuring it in a way that the delegation of the degree of leniency can be made to the sentencing court, the sentencing commission, vastly strengthen the hand of federal prosecutors. That's one way. Second, how am I doing on time? The second form of empowerment I want to speak to you about doesn't relate to cooperating witnesses. It relates to the approximately 80% of defendants who get sentenced but don't cooperate. Right? These motions I spoke about up till now, these 5K motions get made in roughly 20% of cases nationwide. And there's some aberrations, but they tend to be relatively uniformly distributed among the circuits. I want to address now folks who don't cooperate, but who plead guilty and proceed to sentence. Now, when these sentencing guidelines came into play in 1987, all of us in the system, prosecutors, defense lawyers, judges, probation officers, everybody, believed that the percentage of cases that went to trial would rise dramatically. Now, the guidelines prescribe very long sentences, at least in our neck of the woods. They seem much longer. They were much longer than the sentences offenders were used to getting in the pre-guidelines era. And so the incentive to plead guilty was modest as a result. Now, a defendant who clearly accepted responsibility, to use the terminology of the guidelines, and that essentially meant, not necessarily, but essentially meant pled guilty. That defendant was given a 2-level adjustment for acceptance of responsibility. A couple of years later, they added a 3rd level for people who pled guilty early, but still, all that remained was a 3-level downward adjustment for foregoing trial and pleading guilty. Now, to give you an example, a typical drug defendant who faced a 70 to 87-month range if convicted in trial faced 51 to 63 months if he pled guilty. Now, that kind of break, we all thought, everyone, undervalued the risk of acquittal if the person went to trial. Will be on trial all the time, we said to one another. And in fact, a lot of us were pretty excited about that fact. I, for one, was. A lot of people become prosecutors and defense lawyers to try cases. We thought there'd be a boom in trial work. We were all wrong. It hasn't happened. In fact, exactly the opposite has happened. Whereas roughly 90% of sentenced defendants were convicted after trial, whereas roughly 90% of the sentenced defendants were convicted by a guilty plea in the pre-guidelines era. That number is now up to 96.6%. It's crept steadily upward in the guidelines era. Trials haven't disappeared, but they're significantly less frequent, far fewer than half the number of trials. Why? I believe actually there are lots of factors at work, but one is certainly the prosecutor's power under the guideline system to manipulate guideline ranges. And this power enables them to offer plea bargains in many cases that get the defendant far more for pleading guilty than just the 3 levels on for accepting responsibility. Now, the means of empowerment is built into the guideline system itself. We have a detailed set of guidelines that set forth innumerable opportunities for prosecutors to exercise this power. For example, a fraud defendant's sentencing range will depend on a bunch of factors, among others the amount of the loss caused by the fraud, whether sophisticated means were used to commit it, whether the defendant had a mitigating role in the offense. If so, how mitigating, 2, 3, or 4 levels. Any number of other potential litigation points along the road to computing the guideline range. Defendants often plead guilty in exchange for a prosecutor's agreement to take lenient positions on factual issues like this that directly bear on the defendant's sentencing range. Sometimes this bargaining occurs when the facts are genuinely unclear and the prosecutor simply agrees not to advance the more aggressive of the plausible arguments about the sentencing adjustment. On other occasions, though, the facts are plenty clear, but the prosecutor nonetheless agrees to recommend and support a more lenient result than the facts of the case warrant, a more lenient calculation of the guideline range than the facts of the case if applied faithfully to the guidelines were produced. This practice is described by Professor Schulhofer and Nagel as guidelines factor bargaining. They observed in 1997 that guidelines factor bargaining is common. It's based on studies in, I believe, 10 districts of plea bargaining practices. That guidelines factor bargaining remains common, especially in connection with the role in the offense guidelines provision. That particular feature of every sentence is fertile ground for guidelines factor bargaining because there can be an upward adjustment of 4 levels, 2, 3, or 4, a downward adjustment of 2, 3, or 4. It provides play in the joints of 8 levels, which at the spot on the chart that most defendants find themselves can affect the sentencing range by 75 to 90%. So that provision in particular is attractive to folks who want to bargain with the guidelines factors. Schulhofer and Nagel report that the plea agreement, which contains the parties' estimate, the artificially low estimate of the guideline calculation, is rarely made binding on the judge. In fact, it can't be binding on the judge unless it's done under 11A1C of the Federal Rules of Criminal Procedure. But the sentencing judges, for lots of reasons, institutional, and in part because of a sense that the guidelines are too severe to begin with, rarely buck the agreed upon guideline calculation, even if it's factually dubious, and even if the factual dubiousness of it is plain from the pre-sentence report. I see this kind of often, to tell you the truth. And to their credit, the prosecutors in my district have on occasion been candid in admitting their guideline factor bargaining to me. The degree to which the guidelines are compromised by the exercise of this power by prosecutors is very difficult to quantify, mainly because the results of these bargains appear in the Sentencing Commission's data as a straightforward within the guideline sentence. It's just improperly calculated guideline range. Schulhofer and Nagel estimate that the guidelines factor bargaining produces a circumvention, as they call it, of the true application of the guidelines in 20 to 35% of cases resolved through a guilty plea. How long would you like me to speak? As I say, I could go for 3 days, but I won't. Let me just take a couple more minutes. A logical question, to my mind, that's raised by this practice, this prosecutor's practice of exercising sentencing authority by, in their plea agreements, compromising the guideline range, is why prosecutors and defense attorneys aren't more straightforward about it. There's an element of underhandedness, right? Obviously, it's wrong to withhold facts, or even worse, misrepresent facts to a sentencing judge. I think you don't have to be a sentencing judge to agree with that proposition. And the guidelines factor bargaining involves that type of conduct. There was a survey by the probation officers advisory group back in '96, which advises the Sentencing Commission of probation officers who conduct pre-sentence investigations, who reported a great deal of stipulating the facts by prosecutors and defense lawyers, and the facts were incorrect. They stipulated to a certain amount of drugs being involved in an offense, but the probation officer would speak to the FBI agent, who would report that they could plainly prove, beyond any doubt, a higher quantity of drugs, which would drive up the guideline range. And to me, a logical question is why otherwise upstanding members of the bar wouldn't be more straightforward in accomplishing their goal. If the purpose of the plea agreement is to have the defendant sentenced based on a guideline range that's more favorable than the true guideline range would be, why not just do it directly? So I mentioned earlier, 11E1C allows the parties to agree on a specific sentence or a specific sentencing range that the defendant will be sentenced to, subject to the court's approval. So it expressly permits an agreement, the rule does, expressly permits an agreement that will compromise a faithful application of the guidelines. Why don't they do it? Again, this area of the law is complicated, and many factors are at work, legal and institutional and practical. But I have no doubt that one cause for this not being done above board and more transparently is that the Sentencing Commission has tried to prohibit exactly that kind of agreement. Whereas the Commission seems entirely at ease with the prosecutorial power conferred by 5K 1.1, the cooperation that I addressed earlier. The power to manipulate guideline sentences for people who plead guilty but don't cooperate does not sit well with the Commission. It has tried mightily to prohibit such agreements, and it's done so in a section of the guidelines called it's a policy statement, 6B 1.2. And what it does is it sets, well, I'll read it to you. It's an interesting provision. In case of a plea agreement that includes a specific sentence, under Rule 11E1C, or a range of sentence. They don't say that, but we know the range is permitted. The court may accept the agreement if the court is satisfied either that, one, the agreed sentence is within the applicable guideline range, or two, the agreed sentence departs from that range for justifiable reasons. Let me pause just briefly. On the first prong, it says that the parties can agree to a sentence, but it can be accepted only if it's already within or is the applicable range. I've never seen such an agreement, probably because there's hardly anything for the defendant in it, right? All the defendant gets in such an agreement by way of the plea agreement is eligibility for a sentence that he's eligible for even without the agreement. So you don't see those. The second prong looks much more promising, right? The second prong is the judge can accept that agreed upon sentence if it departs from the applicable guideline range for justifiable reasons. That's the language of the guideline provision. Well, justifiable reasons, there's an empty vessel if ever I saw one. And we judges are always looking for empty vessels. And it looks like an invitation for district courts to allow these agreements for any one of the numerous reasons that they're entered into, right? Chief among them is the risk of losing the case. Both sides want to hedge against the risk of loss. And plenty of other reasons. Defendants' desire to avoid the inevitable additional investigation that goes along with getting ready for trial. The prosecutor may not want to use an accomplice witness in that trial. They want to save that accomplice for another trial. And the prosecutor may have a vacation plan for the date the trial is scheduled. Lots of reasons. And it looked as though judges could accept those agreements for any one of those justifiable reasons. Not so fast. Without any explanation, in 1989, the Commission amended the commentary to 6B1.2 to define and narrow that term, justifiable reasons. Under the amended commentary, the commentary has the force of law. A judge can accept a plea agreement that compromises a guideline range if the agreed-upon range departs from the applicable one for reasons that would warrant a departure. These are the departures I mentioned earlier, for reasons other than cooperation. In other words, here too, the parties can agree to a sentence only if the defendant is eligible for that sentence, even without the agreement. Now, this is a strenuous effort to do a couple of things. One is to expand the intent of restricted discretion beyond the judiciary, the perceived problem to begin with, and have it embrace prosecutors as well, right? Having been unleashed on the world to cabin the discretion of sentencing judges, the Sentencing Commission has decided that it does not want that structured discretion to be undermined by prosecutors who have the power to achieve by plea agreement the same sort of unwarranted disparities in sentence that the Commission believes produced the guidelines to begin with. It hasn't worked. The Commission's effort, the second thing the guideline does is attempts to place federal judges in the role of police for the Commission, right? The guideline prescribes a rejection of a plea agreement that compromises a guideline range unless you could get to that agreed upon plea even without the agreement. So the idea is we'll restrict the discretion of prosecutors, not just judges, and we'll use the judges as our police. Hasn't worked. There's actually some debate, there's some competing circuit decisions. The D.C. Circuit Harry Edwards wrote a case wrote a decision last year in the United States versus Goodall that says that 6B 1.2 can't mean what it says. The First Circuit has said otherwise. It was called Carousel, cited in the Goodall case. But the fact of the matter is the issue hardly ever comes up. It hardly ever comes up for obvious institutional reasons, right? In order for it to come up, someone has to complain about it. And when you have two adversaries who are no longer adversaries, they agree on a particular disposition. Unless the judge wants to do something about it and query whether we have the institutional wherewithal to do anything about it, even if we're so inclined, it doesn't percolate up, it doesn't get litigated. And the fact of the matter is 11E1C agreements are accepted all the time, notwithstanding 6B 1.2. To my mind, this is a reallocation of power to prosecutors that the Commission is very upset about, but shouldn't be. It's in essence, in my judgment, a natural corollary to the enormous power the executive branch has to bring prosecutions. To begin with, seems to me plain that if prosecutorial discretion embraces the power not to prosecute at all, even not to prosecute one of two similarly situated defendants, it strikes me as plain that it also embraces the power to prosecute one of those two less rigorously, less vigorously than the other. I don't want to keep going on because I won't stop. Let me ask whether you have any questions. And they don't necessarily have to, if you have questions about the guidelines generally, feel free to pose them. So,
There's actually an interesting article about privatization of civil law that I find Bar Association that we receive as students which one. And it sounds like what's going on with the guidelines is similar to respect that inactive records across the course. Inactive record reproduces criminal cases. In civil cases aren't generated, whether it's as the case is settled or the arbitration, which is a sealed record, or whatever it may be. And that the legislature is continuing to attempt to create principles to have the judiciary is forcing a lot of real just outcomes outside of the court.
the point's well taken. It's a treacherous analogy because, notwithstanding what I said about how prosecutors and defense lawyers can circumvent the guidelines, compared to the civil side, privatization you speak about, another related issue is the sealing of records once a case is settled. Compared to that, the accessibility and transparency of federal sentencing is enormous. I actually think, I'm not troubled by it, to tell you the truth. I think what it shows us is there was an effort to make national sentencing uniform. There were many other efforts to make state sentencing uniform. It's much easier to achieve some consensus, some unanimity in the state of Minnesota, Pennsylvania, to get two guideline states, than it is in our country. It's a big country. Crime is perceived differently in different areas of the country. Punishment is perceived and imposed, and always was, dramatically different. If you get caught with, when I was chief of the criminal division in Brooklyn, if you got arrested with less than a ton of marijuana, the declined prosecution sent you off to the state. Now, if you get arrested with a ton of marijuana in Nashville, you're on the front page, right? And these differences, we all understand them. They're a matter of common sense. The guidelines sought to blunt those differences, not to blunt them, to eliminate them. They haven't done so. They have blunted them. And I think, the fact of the matter is, sentencing is disparate regionally. The sentences imposed in Brooklyn are different, significantly, than the sentences imposed in Miami and in Richmond and Chicago. And the way you get there, the ways you get there are different. Sometimes it's a departure power. Sometimes it might be through this manipulation of the guidelines. But you get there. The differences, no doubt, are not as stark as they were in the pre-guidelines era, but they're impossible to stamp out. And having blunted them, to my mind, having made them less striking, the commission, and having erected a sentencing regime that is so transparent. The mere fact you have to make factual findings, you can be subjected to appellate review, is great. But just what the commission has managed to accomplish, I think, is terrific. And I'll be happy with that. The notion that sentences will always be imposed, that an illegal re-entrant will be sentenced the same in Southern California, where they have literally thousands of them a year, as in North Dakota, where they have a handful. It's just never going to happen. And I don't think it should happen. Yes?
I don't know enough to answer specific questions,
So I probably don't know enough to answer it anyway.
So that's a general question. With these terrorism cases that are now winding their way through the courts, how does sentencing guidelines deal with terrorism differently than it would with organized crime or drugs? I ask because we have these people, these 6 men being prosecuted in Lackawanna, New York, under a terrorism charge. to me that they would be dealt with very differently if it was some type of drug dealing or organized crime type of conspiracy. So I was wondering how the sentencing guidelines work, that something like that out.